Hey guys, this is Jules with True Crime Reactions. Disclaimer.
Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged.
Okay, the next one in the very long list of documents that we are going over in that huge document drop from the state when it comes to the Idaho 4 case. Right now, they are in arguments when it comes to getting rid of the aggravators for the death penalty. We've gone through a few of them so far. Now, the last one that we did was for the fight over the removal of the HAC aggravator, which is where they are deeming the crime heinous, atrocious, and cruel. That video looks like this, and a link for it will be also in the description box. Now, this next one is the motion to strike multiple victims aggravator. I'm going to tell y'all straight up, just like in the last one, this argument aggravates the crap out of me because it feels like they're trying to minimize what actually happened here. And again, regardless of how I feel about the defendant and the evidence they really don't have against him, I'm also not okay and not just going to sit here and be okay with any old thing being thrown out there just because it fits the Bryan might be innocent narrative. That's not how I do things. Okay, let's see what the state had to say. Okay, it starts out. Comes now the state of Idaho by and through the Latah County prosecuting attorney and hereby objects to the defendant's motion to strike the multiple victims aggravator in this case. And we already have a footnote. It states defendant is referring to Idaho Code section 19-25159B, which applies when at the time the murder was committed, the defendant also committed another murder. Hello. We have 4 here, okay? Going forward, the state will refer to this aggravator as the multiple murders aggravator as it more closely reflects the statutory language. Multiple murders, multiple victims. I mean, yeah, same thing, but murder means end of life. Victim could mean the person is still alive, so I understand the reasoning behind that. For the following reasons, the defendant's motion should be denied, and it should be denied because there were multiple lives lost. 4. Kaylee, Maddie, Xana, Ethan. Not just 1, not just 2, not 3, but 4. Multiple. Regardless of the DNA that is lacking in this case, the fact remains 4 people lost their lives. And regardless of how the defense is wanting to defend their client, this argument, the fact that they filed this is complete crap, and they know it. Argument. Defendant does not make a legal argument in his motion to strike the multiple murders aggravator. Instead, he attempts to craft a public policy argument. And that is what it seems like most of these arguments are. There's nothing about the crime itself in any of these documents so far. It's all, oh, this case did this, and this case said that, and this is what happened over here in this one in this state from 25 years ago. None of this is case fact. That's why to me it sounds and it is like a huge waste of money, regardless of who is paying all of the fees for this crap, okay? It's a waste. It's a waste. None of this matters if the case isn't there. There'd be no reason to talk about there being multiple murders or multiple victims if that wasn't the case actually at hand. So again, I don't know how they can have these arguments and expect the judge to make any decisions on these things without him having actual case fact itself from the crime scene. Unfortunately for the defendant, there is no legal authority that supports his motion. Defendant claims murders cannot be aggregated in a manner that makes the act of a malice aforethought murder aggravated. What did I just read? Let me reread that. Murders cannot be aggregated in a manner that makes the act of a malice aforethought murder aggravated. I mean, I'm not going to pretend like I know what that means. So malice aforethought is also known as mens rea. I've heard that term a few times, and it says it's still used in the criminal justice system today when trialing for murder. The term is a catch-all phrase that encompasses all of the states of mind that are sufficient mens rea for murder. So the state of mind, what the person's thinking whenever they do the things, I guess. They are then citing the defendant's motion to strike the multiple victims aggravator that we just went over a minute ago. He badly asserts there is no way that in which two murders can be aggregated in a way that makes the act of murder aggravated, except to resort to one of those other aggravators. See, this aggregated and aggravated stuff is like sort of messing me up a little bit. Let me get some clarification in my own brain and then give it to you guys. I sort of already figured what aggravators actually was defined as. It's really like circumstances, everything about the case when it comes to, like we talked about with the HAC. If it was quick and done within just a few minutes, like they're claiming, then there is no time for there to be suffering for the person to enjoy. There's no time for torture. There's none of the things that fall into those definitions. So it's part of that. It's part of just like things of the case that make it worse than a normal crime. So it looks like aggregated, it just shows that they're trying to put all four of the murder cases and the burglary all together in one thing, which is what this is. So it's just a bunch of pieces being put together like a puzzle. Aggregated is just everything getting put together into one case, regardless of how many charges there is, which is, again, what we're seeing in the Leilani Simon situation. There's multiple charges, like in the teens, from what I can understand. That's on the charge doc. And there's only one case number. There's only one case. So yeah, that makes sense. Now I understand it. In support of this contention, he does not cite a single statute or appellate case, but rather an article from the New York University Review of Law and Social Change. So nothing official was cited. It was a news article. Okay. The article does not even stand for the proposition that defendant claims it does. The article does not argue that multiple murders is not an appropriate aggravator for a capital case. Rather, the article analyzes a study in capital cases in Texas, which is not Idaho, okay, and the extent to which non-legal considerations play a role in prosecutor and jury decision making. The article is summarized as follows. The present study seeks to determine the effects of several legal and extra-legal factors on prosecutors' decisions to seek death sentences and juries' decisions to impose life or death sentences in Texas. Side note, there's one going on in Texas right now. There's a man that was on death row for killing his child, but after everything that they've like gone back in and re-looked at, they have proof that it wasn't him that did it, that she actually died from medical conditions, and that what ended up happening to him was incorrect. Like he was blamed for all this stuff and it wasn't true. And he's been given a stay of execution and his case is going to be being looked at again, which is great news. Stuff like that is what makes the death penalty horrible. Horrible. And I agree with a lot of people that say that it shouldn't be a thing, period, because there are so many mistakes. But then you look at people like Ted Bundy, like Charles Manson, like the Gainesville Ripper. I mean, like your random okay? Those people don't deserve to breathe our air. They just don't. So I can't sit here and say that I'm just completely against it because there are issues with it. We need to fix the problems. We need to fix it. We need to correct it. But when it comes to certain creatures that are living amongst us, they shouldn't be. They shouldn't be. And they shouldn't be housed and able to just live their lives knowing that they got to live out their fantasies. Because everyone has an expiration date. Them being put on death row or whatever doesn't matter to me, honestly. We all die, okay? You're not giving them any sort of punishment that they're not going to eventually endure anyway, because we all die, okay? So when it comes to the death penalty, I don't want those people to be around. I don't. And a lot of you guys agree with me on that. But I do see the problems with it. But there's always a middle, and people would rather this way or that way than meet in the middle. And that's the biggest issue with government and politics and pretty much like everything else. So we're not going to get into all of that here on this channel, because I could go on and on and on several subjects about the boo-boo over here and the boo-boo over here, and how you can take a little bit of each one and put it in the middle and make everybody happy, and it works perfect. But nobody really wants to do that. They don't want to give up complete control, and it's really, 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 really sad. Okay, it goes on to say, many legally relevant factors, such as the defendant's prior record and the killing of multiple victims, which would be expected to influence the punishment decision, are considered. Factors not legally relevant to the case include individual characteristics, such as race or gender, of the offender and victim. The prosecutors and jury's decisions were not made on the basis of legally relevant factors. It may be concluded that the death penalty was imposed arbitrarily. If decisions were based on extra-legal legal factors, it may be concluded that the punishment was imposed discriminatorily. Ooh, I got that right on the first try. Finally, if the decisions were consistently based identifiable legal factors, the conclusion may be drawn that death sentences were fairly and equitably imposed. Put another way, the article specifically refers to multiple victims as one of the legally relevant factors to consider in capital cases, and further states that death penalty sentences are fairly and equitably imposed when such factors consistently form the basis of decisions to impose the death penalty. If this article can be read to present any opinion at all on the multiple murders aggravator, it is that it is a fair, legitimate, and appropriate consideration in a capital case. Citing to State versus Abdullah, defendant further asserts the multiple murders aggravator violates the Idaho Supreme Court's prohibition on double counting. Oh my gosh. State versus Abdullah did not even involve the multiple murders aggravator. The Idaho Supreme Court simply reiterated the well-established standard that double counting or double weighing aggravators is impermissible. So they're basically citing from the past few arguments. The state has been claiming that the defense is citing a whole bunch of cases and a whole bunch of things that technically don't have anything to do with this case or are giving the opposite argument that the defense is trying to portray. Interesting. In this case, the state intends to present evidence that would allow a reasonable jury to find all statutory aggravators without engaging in impermissible double counting by presenting additional evidence for each statutory aggravator. Okay, but that's not really true. I mean, I don't know if they're talking about this case or if they're talking about the cases that they're talking about, which is why, again, these documents are a little like back and forth. But from what we've heard so far, if this is talking about the Idaho case, I don't know if the defense is planning on actually presenting anything at all, because all they've been claiming is that they were going to be able to use everything from the investigation and the state to prove Bryan's innocence without having to do anything else. So again, I don't know if he's talking about this case or if he's talking about the ones that they're referencing, but I'm just going to go ahead and leave that little reminder in there as it is. Then they cite State versus Charbonneau from 1989, states that it was overruled on other grounds by State versus Card from 1991. Further, there is no reason to doubt that the jury will be instructed that they may not double count or double weigh the evidence. See, that's a whole other thing. Like, they're basically trying to state, the defense is trying to state that, yeah, 3 additional lives were lost, but why do we have to count those extra 3? 1 was enough for the charge. That's how I am hearing it in my brain, okay? Idaho Criminal Jury Instruction 1723 addresses this very issue. The state has alleged more than one statutory aggravating circumstance in this case. You must consider whether the state has proven the existence of more than one statutory aggravating circumstance beyond a reasonable doubt by relying on the same facts or independent facts. The same facts without more cannot be relied on to find more than one statutory aggravating circumstance beyond a reasonable doubt. Independent facts must exist for each statutory aggravating circumstance in order for you to find that the state has proven multiple statutory aggravating circumstances beyond a reasonable doubt. Idaho Criminal Jury Instruction 1723, multiple aggravating circumstances. And here is the little link. Let's go to it. We did look, it's the same one, okay? We did look at this a couple videos ago because I noticed that May 22, which is May of this year, which is a year after the grand jury indictment and after the defense team has already come in here and argued about the grand jury instructions all the way up to the Supreme Court and it was denied, that suddenly May of this year they have updated death penalty criminal jury instructions. Found that interesting. Thus, any argument that the jury would disregard the instructions provided to them and engage in impermissible double counting is purely speculative because jurors are presumed to follow instructions. Conclusion. Defendant has failed to provide any binding legal authority for this court to strike the multiple murders aggravator. Instead, he provided the court with a law review article that favorably describes it as a legally relevant consideration in an Idaho case that did not even address the multiple murders aggravator at all. His motion is legally meritless and should be denied. And then we have the certification of delivery. Okay, so the defense has actually responded to what we just read already. Right now, it is October the 26th, Saturday, and as of Friday, October the 25th, there has been a new batch of documents. I posted a few of them this morning. It looks like this. So I'm going to go ahead and include that in this video so we can just wrap up the argument altogether. We are starting off with a mistake. The D in defendants is missing. So they really must have just like rushed through all of these to get them submitted by the end of the week. They do that a lot, these massive dumps on a Friday. So yeah, this feels really rushed. There's been a lot of mistakes and we're not even halfway done yet. So anyway, reply to state's objection to defendant's motion to strike multiple victims aggravator. Comes now Bryan C. Kohberger by and through his attorneys of record and submits the following reply to the state's objection to his motion to strike the multiple victims aggravator from the state's notice pursuant to Idaho Code 194004A, which is the death penalty. Mr. Kohberger had argued that Idaho's multiple victims aggravator is unconstitutional as it does not actually accomplish any narrowing except as a more specific form of the propensity aggravator. The state in its response ignores this argument, instead cherry-picking from Mr. Kohberger's briefing and setting up its own strawman arguments to knock down. This largely consists of reading the sum of the authorities Mr. Kohberger... Should that be SUM? Consist of reading the sum of the authorities? I feel like that should be the SUM. Okay. Cited for particular propositions and then claiming he used them to stand for something else entirely, such as prosecutorial and jury decision-making in post-Furman capital cases. Mr. Kohberger indicated that in Texas, the presence of multiple victims was important for determining future dangerousness. Are you trying to discredit this? It sounds like they're giving it like a stance. The state claims that Mr. Kohberger had argued that the article is against the use of multiple victims as an aggravator. Okay, so the defense stated that it was important, but the state is claiming that they claimed the opposite, which isn't true. There's just so much like back and forth cray-cray. Mr. Kohberger does not think that what he's arguing is so nuanced as to completely escape the state's ability to refute it. But given that the state provides no response to what he has argued, he sees nothing he can reply to. I mean, yeah, technically, like they're both doing it though. They're literally just arguing on policies, and the state's just finding like little things within what the defense is claiming about those policies to also like argue about. Like that's the entire state's argument, is just nitpicky stuff off of what the defense submitted. It's really pretty much all it's been. Mr. Kohberger asked this court to strike the multiple victims aggravator as it merely doubles the propensity future dangerousness aggravator, which he argues against in its own merit elsewhere. Yeah, like they're using the fact that this puts more validity on the future dangerousness aggravator while they're also trying to get rid of the future dangerousness aggravator. They're like using them as their own arguments. Now that we've heard all sides, what do you guys think? I don't understand how they can try to get rid of this, why they would even feel like it's okay or appropriate to get rid of this. Again, I'm not a lawyer. I obviously, from you seeing me look up definitions of things and try to figure things out that way, I'm trying to understand what's being told to us here. And it's really hard to understand why the defense would use this argument whenever they're trying to claim that their client was nowhere near that event at all. Because the only thing that I can really think of, and somebody's probably going to take this out of context. I don't honestly care anymore. People are just going to do what they want to do. Okay, humans are going to human. But this is the only way in my brain it makes any sense, is if somehow they're going to try to play it as if Bryan was one of many and he only technically took the life of one. But they can't really use that argument because the defense is claiming this entire time that Bryan is completely innocent, and that instead of being in Moscow that night, he went the opposite direction. So it can't be both. But those things do cross my mind in the thought process, but we have to remember everything when it comes to this case. So it's more like, I don't understand what the point of them trying to take away some of the seriousness and almost like undermine the case, because like I said, we had 4 lives lost. Like, I shouldn't even have to say that. Like, duh, we had 4 lives lost. There was multiple victims. There was multiple murders. What do you mean? I just don't understand why this is the argument they're choosing when it comes to trying to defend their client. And I know, like a lot of people have said, that they're trying to cover all their bases. I get that. But this just seems like a inappropriate argument. Like the future dangerousness one, I understand them wanting to argue with that one, because before somebody gets proven innocent or guilty, there's like this thing hanging over the entire thing, because you have to determine whether this person is going to be dangerous later on. So I mean, I understand that, but this feels like the facts of the case is 4 lives, 4 victims, 4 murders. So how can that be something that's argued? It's just very strange to me. Like, taking 1 life is one thing. The capability to take 4 is a whole nother situation. So, regardless of the defendant and how I feel about the evidence or lack thereof in this case, this feels like a strange argument. And that's just my opinion. But again, I want to know what you guys think down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on your way out. Subscribe to the channel if you were not subscribed already. And don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.